Good morning, friends. Namaskar, Sasriyakal, and Adab. This is my 278th video, and in this video, we'll be covering a topic of fixed size of grants. This will be the nail in the coffers of the Governor General orders passed, and which clearly said these regulation rules for the administration in these three distinct presidencies called Bengal, Madras, Bombay, also called the regulation provinces. Simultaneously, various army regulations were passed for all the three presidencies. Likewise, Bengal Army regulations 1855, 1873, 1880, 1870, 87. And for Madras Army regulations, it was 1869, 1876, and 1887. Likewise, for Bombay Army Regulation 1875 and 1887. So, the last Army Regulation of all the three presidencies was 1887. As by 1879, the Army organization had recommended the abolition of the three armies. During these years from 1792 to 1895, all these separate presidencies adhered to one rule of law, and that was if any land was to be granted within any military cantonment since 1789 to 1801 in Madras Presidency, or since 1789 to 1803 in Agra Province, or since 1789 to 1817 in Bombay Presidency, and lastly, since 1859, the making of Lieutenant Governorship of Punjab. Now, friends, why have I used these dates? Please make sure you remember these dates and you are able to plead them in your advocates. So, the Governor General or the General Order dated 27th April 1789 very clearly reads no private bungalows or buildings to be erected within the limits of cantonments unless the permission of Commander in Chief. But if we read, there could be private bungalows or buildings with the permission of the commander. It does not say it is a blanket ban. Now I'll read an extract proceedings from Governor General in Council dated 6th August 1801. Now His Excellency in Council, however, thinks it proper that uniformity should be preserved as much as possible in the principal lines of directions of the bungalows, in their distance from one another, and also in the dimensions of the bungalow. And His Excellency in Council desires that this may be addressed to with reference all his formal orders, that would like the honorable courts now to understand that the desire of uniformity of dimension and direction was as per regulation 20 of 1810 of Public Works Department, that is PWD of the present, which clearly reads that all limits of cantonments and garrisons, including military bazaars, shall be marked in all cases under Regulation 3 of 1809, under Section 4 by the Commander in Chief in connect with the magistrate. Now, this magistrate is now the collector or the DC of your district. This regulation was extended under the Code of Regulation of Public Works Department, that is PWD 1855, read section 5. So, meaning by from 1810 till 1855, the law was very clear that all grants had to be of a fixed size. So 1836, 1828, and 1837 all fall within this period where grants were given under GGO 14, 179, and 260. Now, Code of Regulation of Public Works Department, 1858. The commanding officer at each of those stations for which a report of the nature hereby described has not been already furnished under Section 4, Regulation 3 of 1809, will accordingly submit to government through the Commander-in-Chief without delay a report framed in concert with the magistrate, now collector of the district in which the cantonment or garrison may be situated upon the local limits of the cantonment and garrison, forwarding at the same time any separate remark which the magistrate may wish to make on the subject for final orders of the government. So the boundaries of cantonments, when confirmed by government, should be marked by pillars, which are to be supplied where whenever they have been destroyed or are not forthcoming. So are pillars for your cantonments coming? Any existing village within the limits of the cantonment should also have its boundaries marked by pillars, beyond which it should not be permitted to encroach. So understand, 1810, 1858, the limits were to be marked, and a village could be brought in within the military station. So what are we trying to say? That the ground allowed for the compounds of others of all branches of the army is as follows. A field officer will get a dimension of 83 by 1 by 3 into 50 yards. A captain is going to get 61 by 2 into 50 yards. A sub-lieutenant will get 50 into 50 yards. So these are the dimensions which the bungalow is to be given. The portion of the land allowed to the officer of the army could be specified in more better way. A field officer will get approximately 22,500 square yards. A captain will get 1,200 square yards. A sub-lieutenant will get about 7,000 square yards. So we have to understand whether your and my bungalow are of these sizes. No, they start off from 1.62 or 1.8, or they go up till 9, 10 acres. So friends, wake up. Now I'm showing you a chart under army sections which clearly sees under the army instructions, fixed size of grants 1873, 1899, 1898. Limits to be approved under section 1948. Where is it written? It is written on page 333. Section 6, page 3. Bazaar boundary limits to be marked, section 1949, page number 334. Section 8, read page 3. Third, houses to be appropriated for military officers. This is something similar to the House Accommodation Act. Section 1966 at page 336. Read section 35 at page 11. 4. Houses to be sold if not rented. Same provisions as given in the House Accommodation Act in 1902. This I am talking of 1858. Every grant has to be registered. Section 1983, page 339. So 1836, 1858, my grant needs to be registered. What have I explained you in the Registration Act? That Registration and Stamp Act and Transfer of Properties Act started from 1793. So we are living in a fool's paradise that the Transfer of Properties Act first was of 1882. No. Section 1983, read page 339. Section 57 at page 23 clearly speaks this. The last and foremost, fixed size of grants. The Army Regulation, section 1979 at page 338, talks for this. And similarly, in the later Army Regulations, Section 61, page 29. So these books are there, this evidence is there. Is anything left after watching all these my legal videos? And I'll be coming up with more videos. I'm just coming up for these advocates, local bungalow owners, residents. Please watch them out. Maybe what? 1,000 minutes? You save your property. You don't want to come to me. You don't want to take my consultation. Watch them. I'm telling your advocates to listen to them. Why am I doing this? Is only for one reason, because I know it now that the Britishers, they left some loopholes in the General Land Register so that anybody in later part of the country could crack them, assimilate these laws, and garner what is the definition of old ground. I've been always saying we were never converted into new grants because we were revenue free grants. Thank you. Good day.